Welcome to U.S. Immigration TV. Well, the Child Status Protection Act, or Cspa, provides age-out protection for minor children even if they age out or turn 21 years of age. It's based on a complex mathematical formula. Now, I know that when a child is turning 21, parents are anxious, and they think it is best to have the case expedited, or the petition expedited. But sometimes it's not. In fact, expediting a petition could result in a child not being eligible under the Cspa. Now, it sounds odd or counterintuitive that it's better not to expedite a case. Well, watch this video until the end for an explanation as to when it is not beneficial to expedite your case, and in fact, it could possibly mess up your child's Cspa eligibility. And of course, make sure to like, share, and subscribe to this channel. I know every video talks about that, but I really mean it because I'm out there posting these videos on topics I think that you find interesting and that you find helpful. So let me know by subscribing that you like the type of videos I'm putting out. Now, here is a question from a concerned parent which will illustrate my point as to why it may not be wise to expedite a case. So here's the letter. Dear Attorney Gurfinkel, I am a green card holder, and in 2022, I filed petitions for my 2 children who are in the Philippines in category F2A. That's minor child of immigrant. The petitions are still pending, and I'm very worried because one of my children is 20 and the other is 19, and I'm afraid they may age out or turn 21. So this mother was saying that I was thinking that perhaps I could urge the USCIS to expedite the approval of their petitions so they could arrive in the U.S. before their 21st birthday. Do you think it would be a good idea to have their petitions expedited? Very truly yours, MR. Okay, so now here's my answer or analysis to MR. And that is, for most people facing an urgent situation or emergency, such as a child aging out, they, of course, naturally think that expediting the case is the best thing to do. However, when it comes to a child's eligibility under the Child Status Protection Act, or the Cspa, in some cases, it is actually more beneficial not to expedite the case, but instead to allow the petition to be pending as long as possible. And I know it sounds strange, doesn't it? So the reason that it may not be a good idea to expedite is that under the Cspa, the longer a petition is pending, the more time you can subtract from the child's age when the priority date eventually becomes current. The faster the petition is approved, the less time you can subtract from the child's age. In fact, I posted videos on this channel dealing with the Cspa and strategies to increase your chances of your child being protected from aging out. Now, in this particular case, this woman's letter, it may not be helpful to expedite the case based on the current priority dates for F2A if the child is undergoing consular processing, meaning if they're applying for a visa outside the U.S. For example, the F2A priority dates have retrogressed or moved backwards several years. In October 2023, the F2A priority date for the Philippines is February 2019. Now, of course, this example deals with the priority dates for October 2023. It may be in several months the visa bulletin may change and the priority dates may be current again, but this is for October 2023. Now, if the priority date for F2A is February 2019 as of October, and you filed your petition for your children in 2022, there's still several more years before the priority date will be current on that F2A petition. If you now expedite the approval of the petition, and let's say the petitions are approved in 2023, you would only have 1 year to subtract from their age when the priority date becomes current, meaning it was filed in 2022, approved in 2023, that's only 1 year is pending. However, if it takes USCIS a lot longer to approve the petition, then you're able to subtract more time from the children's ages when the priority date eventually becomes current. So for example, if it takes USCIS 4 years to approve the petition, you can subtract 4 years. Now, if the children were in the US versus processing abroad, the analysis may be different because USCIS uses the dates for filing chart, or Chart B, for calculating their ages, whereas the US Embassy uses Chart A on the visa bulletin. It also means, and this is important, you have to closely monitor the monthly visa bulletin to determine any forward movement in the priority days. Now, I understand that the Cspa is very complex and very confusing. What seems clear and obvious, such as expediting the case of a child who's aging out, may actually be detrimental to their case and eligibility. That's why you should consult with an attorney if you have any questions or concerns about your child's Cspa eligibility. And you should do it long before their 21st birthday, as there are strict requirements and deadlines to be met in order to qualify for the Cspa. An attorney can evaluate your case and strategize the best course of action. Now again, I hope you have found this video informative or useful to you, or maybe someone you know. So of course, like and share, but most importantly, let me know you're out there and subscribe to this channel. I'm Michael Gurfinkel, and thank you for watching U.S. Immigration TV.